Good morning, I'm Gary DeWaal, and this is Bridging the Week from November 5th to 9th, and today is November 12th, 2018. Last week, a swap dealer was fined $12 million by the Commodity Futures Trading Commission for a host of purported non-compliance issues. However, it was also sanctioned for allegedly not disclosing in two annual Chief Compliance Officer annual reports compliance issues of which it was aware. Separately, the Securities and Exchange Commission sanctioned the founder and developer of an online platform that offered trading in Ether and ERC20 digital tokens through an automated smart contract that interfaced with the Ethereum blockchain. The SEC claimed that the platform impermissibly operated as a national securities exchange when it did not have the requisite registration or did not transact in accordance with the terms of a valid exemption. Last week, I had the honor of leading a panel on international regulation of fintech developments during FinTech Week, hosted by Georgetown Law School, the International Monetary Fund, and the Institute for Financial Markets, of which I am a trustee. Once again, the organizers of the week's events, Chris Brummer, did an outstanding job in bringing together leading government officials, academics, and private industry personnel to discuss a host of important fintech topics. So I can now return to my regular bricks and mortar job. Let's get started. Commerce Bank AG agreed to pay a fine of $12 million to the Commodity Futures Trading Commission to resolve charges that, from December 31st, 2012 through at least 2018, it failed to comply with various requirements for swap dealers, and for 2 years, it filed Chief Compliance Officer annual reports that did not, quote-unquote, adequately disclose deficiencies in compliance of which it was aware. Commerce Bank, a German-based bank provisionally registered by the CFTC as a swap dealer since December 31st, 2012, also consented to retain an outside consultant for at least 2 years to assess and make recommendations for improvements regarding its swap dealer requirements. According to the CFTC, during much of the relevant time, including currently, Commerce Bank failed to have an, quote, effective bank-wide process, end of quote, to evaluate whether its transactions with certain non-U.S. persons were subject to requirements for swaps under applicable law. Among other things, said the CFTC, the bank failed systematically to assess whether swap transactions with certain non-U.S. persons were required to be reported to a swap data repository and did not routinely assess whether swaps had to be mandatorily cleared or executed on a designated contract market or swap execution facility. As a result, some swap trades required to be reported to an SDR were not reported, and some swap trades subject to a mandatory execution requirement were not executed on a SEF. Additionally, the CFTC claimed that in 2015, Commerce Bank filed a CCO annual report for 2014 that failed to identify material compliance issues identified for the bank in 2014 by an outside consultant that had been retained to assess its policy and procedures for compliance with applicable requirements. Similarly charged the CFTC, Commerce Bank's 2015 CCO annual report, filed in 2016, did not disclose problems with the bank's large trader reporting compliance that Commerce Bank identified in March 2015. The Securities and Exchange Commission brought and settled charges against Zachary Coburn for enabling EtherDelta, an online platform that allows persons to buy and sell certain crypto assets to operate as an exchange for securities for U.S. persons without registering as a national security exchange or operating pursuant to a lawful exemption as required from July 12, 2016 through December 15, 2017. The SEC claimed that Mr. Coburn founded EtherDelta in July 2016, agreed to sell it to foreign purchasers in November 2017, and ceased receiving fees from EtherDelta as of December 16, 2017. According to the SEC, during the relevant time, EtherDelta allowed buyers and sellers to trade certain digital assets, including Ether and so-called ERC20 tokens. The platform effectuated transactions through use of an autonomous smart contract that processed buy and sell orders and memorialized bills on the Ethereum blockchain. The SEC charged that during the relevant time, Mr. Coburn wrote and deployed the EtherDelta smart contract and, quote, exercised complete and sole control over EtherDelta's operations, end of quote. He also apparently approved which digital tokens could be traded on the trading facility. As a result, he should have known that his actions would cause EtherDelta to operate in violation of requirements to register as a national securities exchange or be lawfully exempt. To resolve this matter, Mr. Coburn agreed to pay a fine of $75,000 and disgorge profits of $300,000 plus interest. This is an important decision given that the marketplace violated the law was an autonomous entity. For my thoughts on this, check out the written version of my blog at www.bridgingtheweek.com. And finally, the Commodity Futures Trading Commission proposed by a vote of 4 commissioners to 1 to modify swap trading requirements on swap execution facilities, and by a unanimous vote of all 5 commissioners to maintain the swap de minimis threshold at $8 billion. One of the newest commissioners, Dan Berkovitz, was the dissenting voice of the CFTC's proposed amended swap trading rules. Among other things, the CFTC proposed to amend the definition of a SEF to include certain swap brokering entities, including interdealer brokers and aggregators of single dealer platforms. Broaden the scope of the mandatory trade execution requirement to include swaps subject to a clearing requirement and listed by a SEF or a designated contract market for trading. Eliminate the current requirements that SEFs offer only order book or request for, quote, methods of executions, and instead authorize SEFs to utilize more flexible alternative means of execution subject to enhanced disclosure requirements, and modify the current requirements that SEFs offer participation on an impartial and non-discriminatory basis to solely require transparent, fair, and non-discriminatory treatment to all similarly situated market participants. In his dissent, Mr. Berkovitz said that adoption of the proposed new swap trading requirements, quote, would reduce competition by cementing the oligopoly of the largest bank dealers as the main source of liquidity and pricing in the swaps markets, end of quote. He also claimed that, quote, authorizing discrimination based on the type of entity will permit the largest bank dealers to establish and maintain exclusive pools of liquidity for themselves, end of quote. Well, that's it for this week's edition of Bridging the Week. As always, there is more information in each article, and more articles on the article version of Bridging the Week on the website. Check it out. That's www.bridgingtheweek.com. I'm Gary DeWaal. Have a great week, and until the next edition of Bridging the Week, ciao.